What is a nuncupative or an oral will? I'm Sarah Siedentopf. I'm an estate planning attorney in Atlanta, Georgia, and oral wills are no longer valid in Georgia. It's an old thing, used to be here, they were hard to prove at the time, but not a thing anymore. Georgia now has a law that says wills must be written. You have to be over 14 years of age to write one. You have to be of sound mind. The sound mind standard for making a will is pretty low as well, lower than some other types of contracts. And there have to be witnesses, and these witnesses have to watch you sign, so you have to sign it as well as write it. And of course, an oral will is a spoken will, which has no writing, no signing, and so we won't even worry about whether there's witnesses because it doesn't matter. But it might lead you to ask the question about, well, what about a deathbed gift? And that's technically not a will, that falls into contract law. And there's a very complicated realm of contract law around those sorts of gifts. But essentially, the question is whether it is a completed gift. And if I say to you, as I am laying in my bed, I give you my car, and that's all I say, it's not a completed gift. Now, if I say, I'm giving you my car, please bring that title over here for me to sign, or if I say, I'm giving you my car and I hand you the keys, then we have some contract arguments about whether it's a completed gift because I took some action to complete the gift. Of course, if I actually sign the title over to you, it is definitely a completed gift. We're not questioning it at that point. So that's a slightly different question because, of course, you can still give things away, but whether you actually successfully did is a question of contract law. Gifts are contract law. Gifts that are given ahead of time so you can be sure that they are completed. So if you are looking at a written will or other type of estate plan, please give me a call, and I'd be glad to help. And also please like and subscribe. Thanks.